You will everything to your son. He marries, then divorces. Boom. Half of your wealth goes to your son's ex. That is how nearly 70% of families lose their wealth by the second generation. In some cases, this happens because they chose a will instead of a trust. Many rich people who have a will do not need it. What they need is a trust. You don't need to wait until tragedy strikes because it would be too late to fix the mess. Now let's explore the key features of trusts and wills. A will is a legal document that outlines how your assets should be distributed after your death, but it has its limitations. For one, it goes through probate, which can be a lengthy and public process. On the other hand, a trust allows you to transfer your assets while you're still alive and offers greater control over how and when your assets are distributed. Trusts can also be more private since they don't go through probate. They can protect your assets from creditors and potentially save on taxes too. What purpose does a will serve? A will specifies who gets what after you die. It can also name guardians for your children. For example, if you write a will, you might say, "I leave my multi-million-dollar estate to my son." 3 years later, your son marries. Then he and his wife divorces, and boom, half of your estate ends up in the hands of your son's ex-wife. It may not be as simple as I've described here, but surely this unfortunate situation has happened to too many people, and sadly will continue to happen. Let's discuss another feature of a will. A will must go through a legal process called probate, where a court oversees the distribution of your assets. This can take time and may involve legal fees. And of course, a will only takes effect after you die. Now let's talk about a trust and its purpose. A trust allows you to place your assets into a legal entity, the trust, to manage them during your lifetime and after your death. For example, you might set up a trust saying, "I want the trust to hold my house and manage it for my children until they turn 29 years of age." This means your children cannot wake up one day and sell the house, or your children's wives cannot wake up one day and demand half of your estates when they divorce. The person who heads or manages a trust is called a trustee. The trustee is responsible for managing the assets in the trust according to the terms set out in the trust document and for the benefit of the beneficiaries. The trustee can be an individual, a group of people, or an institution like a bank or a trust company. Another thing about a trust that you must know is that a trust doesn't go through probate, so your assets can be distributed more quickly. And of course, a will can be made public, but a trust cannot. Again, a trust can take effect as soon as it's created, in the case of living trust, and can manage your assets even while you're alive, especially if you become unable to manage them yourself. Most billionaires tend to prefer trusts over wills. Here's why. 1. Privacy. Trusts are private documents. The details of a trust are not made public, which allows billionaires to keep their estate plans confidential. Wills, on the other hand, go through probate, a public process where the contents of the will become a matter of public record. 2. Control. Trusts offer more control over how and when assets are distributed. For example, a trust can specify that beneficiaries only receive their inheritance at certain ages or under specific conditions. Wills simply distribute assets after death, with less flexibility in managing how those assets are given out. 3. Avoiding probate. Trusts bypass the probate process, allowing assets to be distributed quickly and without the cost or delay associated with probate. Wills must go through probate, which can be time-consuming and expensive. 4. Tax planning. Trusts can be structured in ways that minimize estate taxes, which is particularly important for billionaires with large estates. While a will can include some tax planning strategies, it's generally less flexible than a trust in this regard. 5. Incapacity planning. Trusts can also manage assets if the grantor, the person who creates the trust, becomes incapacitated during their lifetime. Wills only take effect after death and don't provide any provisions for managing assets if the person becomes incapacitated. So if you are an average guy with just a bit of stuff, perhaps a will can suffice. But if you own a lot of property, you may consider a trust, as it seems to ensure your wealth is preserved through the generations. Consulting with an estate planning attorney can help you determine what's best for your situation.